Hi, my name is Rachelle Smith, certified personal fitness trainer, professional speaker, and author. Last time, I gave you an introduction to the importance of liability and liability concerns and issues regarding fitness facilities. And I strongly encouraged you to take your facility seriously because there's just so many different liability issues, and I've studied a boatload of cases, and I'm actually going to continue this conversation by highlighting a few more cases to help you understand just the impact that these liability issues can have on a particular facility. Now, these cases come from the IHRSA, which is the International Health, Racquetball, and Sports Club Association. And so first case is Patton versus Spa Lady. All right, so plaintiff sued defendant for injury sustained upon receiving a shock from an electrical outlet installed by an independent contractor. So pay attention, those of you who hire independent contractors, at the defendant's health facility. The issue presented in this appeal was whether the employer of an independent contractor is vicariously liable to a person who is injured on the employer's business premises by an unsafe condition in the premises as a result of the independent contractor's negligence. Okay, the Supreme Court of Alaska determined that significant precedent existed which held the employer liable in similar circumstances. So the significance of this particular case was it held the club liable for the independent contractor's negligence. So many of you, particularly owners, can look at a situation. Those of you independent franchisees, private gym owners can say, well, I have independent contractors in the form of trainers or maintenance personnel, whatever the case may be. They have their own insurance, so I'm fine. Ha ha ha, as this case shows, that's not always the case, because an individual may file a lawsuit against you, your facility, as well as the independent contractor in that particular person's business or association. So keep that in mind, those of you who literally kind of rely on the independent contractors to have their own insurance and it's all on their shoulders. You may carry and you may shoulder some of that liability. So be mindful of that. Next case, McBroom versus Marriott Corporation. All right, negligence case. Plaintiff's heirs sued for plaintiff's drowning death in defendant's spa because plaintiff had alcohol in his system while using the spa, despite warnings from the spa regarding such activity and the fact that the spa was closed at the time of death. A jury determined that decedent was 55% negligent. Defendant was found 45% negligent and had to pay $91,215. So the significance of this case is, hey, that particular individual, the deceased, was drunk, and so a person or a facility may say, well, that person was drunk and it clearly stated that that's an issue or we're not liable. As this case showed, no, even though the individual was drunk, Marriott had to pay 45% of that. Was found 45% negligent and had to pay that $91,215. So not always the case when you think that someone's drunk or intoxicated or high. So keep that in mind. Third, White versus Keechee Lakes. Plaintiff sued defendant for the wrongful death of his wife while using the sauna at defendant's health facility. Plaintiff obtained $450,000 settlement from defendant, and defendant sought indemnification from the manufacturer of the sauna. Okay, to quickly define indemnification, that means to compensate for damage or loss sustained or any type of expenses incurred. Okay, Vermont Supreme Court agreed with the lower court's determination that, as a matter of law, defendant was not entitled to indemnification. Accordingly, it affirmed the court's order granting summary judgment in favor of the manufacturer. Okay, the significance of this, the owner of the facility, who actually, of course, where the sauna was located, was not entitled to indemnification. Okay, so keep that in mind. These are all such important cases. Okay, and I wanted to highlight one final case here, and it's here on top, actually a couple more. Case number 4. In the case of Sheenalot versus Glastonbury Fitness and Wellness, the plaintiff was injured during a BOSU cardio class. You see a lot of those BOSU balls going around there in different facilities. cardio class at Health Tracks in Glastonbury, Connecticut, and sued the gym for damages. The gym defended the lawsuit on the ground the plaintiff signed a liability waiver and moved for summary judgment. Very, very common defense for facilities. Well, a person signed a liability waiver, okay, and they will throw that out there and request a summary judgment. So essentially, the case cannot proceed once a summary judgment is order issued. The court held that the liability waiver was invalid and contrary to public policy. To arrive at this decision, the court considered the following factors. All right, so in terms of the actual layout of the contract, although the buyer's right to cancel was printed in 10-point bold font as required by Connecticut law, the waiver itself was about half that size. All right, number two, the gym's waiver referred to ordinary negligence, a standard found to be confusing and vague. Number three, as the gym was the party providing instruction with greater expertise than its members, it was the gym that had the opportunity to foresee and control hazards. Lastly, the gym's membership agreement was a form contract with little opportunity for bargaining. And so this particular case came from the ConnecticutSportsLaw.com website. So very, very important case. And lastly, I want to highlight a case here, premises liability case here. All right, this comes from Dwyer William Potter attorneys. They're based out of Oregon, this particular law group. Okay, so their client, a longtime Klamath Falls, Oregon resident, won a gym membership in a raffle. The day of her accident or injury was the first time she had ever used the gym. Now pay attention now, owners. How often do you have a stipulation where any new members are, yes, you may offer that particular free training session, free orientation session with a trainer, okay, or do you have different incentives to encourage people to really take advantage of that? What is your usage and adoption rate for those particular new members who come on board who actually do go through the orientation, or do people just start? Do you track those metrics? Because that, from a liability standpoint, is so, so important. You can get people into these classes to help them, or orientations to help them learn how to properly use equipment. Okay, so this lady had never been in a gym before. Okay, their client started to use one of the automated machines. She fell, striking her head on the floor, causing massive head injuries. Okay, her injuries included multiple skull fractures and a brain hemorrhage. Brain damage caused permanent memory problems, a loss of the sense of smell, a loss of the sense of taste, and partial hearing loss. All right, the gym and its insurance company denied that the incident was their fault. They blamed everything on this particular law group's client. Several attorneys turned this client down prior to her hiring this firm, saying that her case was too tough. What's the resolution of the case? They found that the gym had knowingly removed a safety bar from the machine prior to their client using it. They found that the flooring did not meet safety standards. No padding was used. They also found that there was a lack of appropriate supervision and instruction of new gym members. What did you just hear me say? The importance of onboarding your new members, helping and make sure and ensure that they're learning how to use your machines and your facility correctly. They filed the case in court and proceeded with an intensive legal discovery process. They tracked down the ownership manuals for the machine involved, tracked down the machine itself, and tracked down the gym's prior employees. They also hired a nationally renowned gym safety expert, as well as a neurosurgeon and a neuropsychologist to testify to the permanent brain injuries. So, result of this case, the bottom line is the case settled for a very large amount within 2 weeks of trial. So, folks, owners, leaders, liability is huge. I've just highlighted a few cases here in this particular episode. There's just a plethora of cases, all different types of cases, from death to sexual assault to stalking, harassment, sexual harassment, fighting, slip and fall, injury, tripping over equipment, people dying, people dying in saunas, people passing out and collapsing in classes, trainers not being certified, trainers pushing people too hard, trainers not understanding the limitations of their clients. There's so many different forms of liability and so many different cases that have been filed regarding various liabilities. So yet again, I'm challenging leaders to be accountable. I'm gonna quote the good old John C. Maxwell, leadership expert, world-renowned again. Everything rises and falls on leadership, folks. It's up to you. Again, what are the standards in your facility? How are new members onboarded? Are they onboarded? Are they tracked? What type of metrics do you have to follow this? Again, what policies and procedures do you have in place to ensure the safety of your members, to ensure the safety of your equipment, to ensure the safety of your facility? Because as I could spend hours upon hours discussing various liability cases as they involve fitness facilities. And so please, folks, please take this concept, take this issue very seriously, because like I said before, I want all fitness facilities to thrive. I want them to be prosperous. I want them to be successful. I want them to grow. But also, most importantly, I want them to be a source of hope, of inspiration, of positive change, of health, of wellness, of fitness in individuals' lives. Because that's truly what it's all about. That's truly why a facility owner and the staff members need to get up every day, is to realize it is all about the members, it is all about the clients, and their safety is paramount, okay? That's absolutely paramount, and it's imperative that leaders understand that. And so there's a lot of different ways, there's different policies, procedures, rules, and regulations that you can implement if you haven't already. Okay, I've highlighted various cases and different ways and different liabilities that you can think about. I'm going to highlight a couple more in the final episode here. But what I want you to do is just to really think about your facility. Look at some of the strengths and weaknesses. Feel free to pull in someone from the outside to give you an objective opinion, because we can all get tunnel vision regarding our own businesses, our own facilities, anything that's truly our own. We can get, as human beings, we can get tunnel vision and not have an objective view and just tend to be very subjective. And that subjectivity can get you in trouble. And so I encourage you, and I've just really enjoyed digging through all of these cases, really enjoyed studying these law cases. And as you've probably figured out, many years ago, I actually had a few people who were like, Rachelle, you need to go to law school. You would be an excellent lawyer. You'd be an excellent lawyer. Have an interest in law. I've always had an interest in law, but not a passion for law. And so, yes, I have a passion for persuasion. I have a gift of persuasion. I have a gift of building persuasive cases to encourage people to take action. So I kind of took those gifts in a different route, and it's landed me right here, right now, in front of you right now, encouraging and inspiring you in this particular instance of fitness and fitness leadership, but I do it in various realms and in various sectors and aspects of life. So I encourage you, I implore you, continue being the best that you can be, but it's going to take accountability, it's going to take leadership, and it's going to take serious, thoughtful, methodical processes regarding risk management, risk mitigation, and liability prevention in your facility. But I'm confident you have what it takes to pull it off. So thanks so much for your time. Make it a wonderfully fit day.